Okay, let's kick off with Arena Williams on her question, because I think this will be part 2 of the bill, the next stage.
Where their rights are being stripped away by a government that does not care, that it is weakening their position, where it is making landlords empowered to not only kick their landlords out with 90 days for no reason, but also to weaken their rights in other ways. And we've spent a whole part discussing how the government is being so kind with its approach to pet bonds without any sort of analysis about how the market will be affected. Not only will rents continue to rise under this approach, as the Treasury predicted at budget predictions, but also people will be affected here. There is no intention, as the government minister and the chair previously said, for MSD clients and those receiving a benefit to be able to use the benefits to increase their availability of pet bonds. There's no intention here for further work to be done on that. So my question to the minister is, if we're weakening the rights of tenants here by increasing the incentives for investors to buy up more of the existing stock of properties, that's the effect, and at the same time we're making insecure tenants feel like even more desperate that they need to get into a house of their own, both of those factors will push rents up and up. And so, is it his position that Clause 22, which reintroduces 90-day no-clause evictions, will drive up rents? And does he agree with Treasury's predictions of the last budget that rents will continue to rise under his watch?
Tamatha Paul.
And kia ora, Minister Potaka, nice to have you here, and hope that you'll be able to respond to some of my concerns that I'm about to bring up. So, I believe this is the appropriate part to bring up what I was trying to get at previously, but I want to dig into the evidential basis behind no-clause evictions, because, Minister, you're making a really big call in bringing these back, given that this is going to impact more than 1 million renters in our country and make them vulnerable to being evicted and kicked out of their home for no good reason. And so I want to understand where's the evidence, because we were told throughout the Select Committee that the rationale behind this bill was that it would allow landlords and property managers to take a chance on risky tenants by bringing them in and being able to kick them out if they don't like their behaviour. But where's the evidence for that? I mean, that didn't come up at all throughout the Select Committee process in my recollection of it. So I'm just trying to understand where the facts are to back that up, because I don't think they exist. And I believe that the reason that these no-clause evictions were brought back was because it's politically popular to do so, despite the fact that in the submissions on the bill around no-clause evictions, again, 97% of submitters were opposed to no-clause evictions being brought back, and 53% of property managers and landlords were also opposed to no-clause evictions being brought back. So where's the facts to back up bringing them back, given there is such huge risk to the 1 million plus New Zealanders who are now vulnerable to being kicked out for no good reason at all?
Honourable Carmel Sepuloni.
Mr. Chair, I sat through the submissions, and this was the most contested part of the bill. So many issues were raised with the additional vulnerability that will be put on tenants as a result of reinstating the no-cause termination for tenants, Mr. Chair. And we were all concerned sitting in that Select Committee. I'm concerned that we're going to see more transient families, concerned that we are going to see families discriminated against, and they will not take up their right to that retaliation clause that's in here, because that is incredibly complex. And as we know, many of these vulnerable families are not likely to go to the Tenancy Tribunal to complain about their landlord. Mr. Chair, there are a number of things that I'm concerned about when I look at even the disclosure statement for the bill and also the regulatory impact statement. I want to know from the Minister why he has decided to ignore the advice in the regulatory impact statement where it states landlord's ability to terminate a periodic tenancy in any other case, a no-cause termination, was considered to negatively impact tenant well-being and disincentivise them from exercising rights and raising concerns. That's what I was just speaking to, and it's actually in the advice that accompanies the bill. The statement also noted that although the RTA enables tenants to challenge terminations they suspect have been issued in response to them exercising their rights, tenants may not feel empowered to do so, as it may be difficult to prove this if no reason is provided. Mr. Speaker, I need to question the Minister on how he will allow this to go through, why he will not consider any changes, given the fact that the submissions were overwhelmingly opposed to this, and even the officials' advice state or reiterate the same concerns that were raised by, I do believe, as Tamatha said, 97% of submitters, Mr. Speaker. Mr. Speaker, during the Select Committee process, Mr. Chair, I raised a question that was unable to be answered by the officials. However, I wanted them to go away and see if they could find the answer, and I'll put that question now to the Minister. And that question is in relation to how long it actually takes an individual or a family to find and secure another rental property once they leave, have their tenancy terminated, the property that they are residing in. Because I'm concerned, Mr. Chair, that we were never presented with any evidence to show that in In cities, in areas where there are housing shortages, places like, I can say, West Auckland, where it's quite often difficult to secure a rental, that 90 days may not even be sufficient for that family or individual to be able to secure their next rental property. Mr Chair, as an electorate MP, we have seen this over the years, particularly, I have to say, between 2008 and 2017, where we had a number of constituents who would come through our office very clearly stating that they were not able to get into another rental property, and so therefore we're in a position where they were seeking out emergency accommodation because of the fact that rental properties were not widely available or easy for them to access. So I want to know from the Minister whether or not he received any advice on the risk of those who have their tenancies being terminated and not able to find their next rental property, having to seek out support from MSD for emergency accommodation, and what that might mean for the Minister's own target of reducing emergency housing in this country.
Honourable Kieran McAnulty.
Very much, Mr Chair. It's pretty disappointing, to say the least, that the Minister hasn't taken the opportunity to stand up and respond to what are genuine and frankly straightforward questions. Because if we are actually to be able to dive into this part, the substance of the bill essentially, we need to understand the government's rationale. We need to understand what they have based that on before we can actually look in great detail about why they've landed, where they've landed, the number of days, etc. Because we know that when this bill was announced, and as it has progressed through the parliamentary system, the government have claimed that this bill will help address the housing crisis. Now, up in the first part, we have discussed this, I think, quite constructively. We've come with ideas on how to improve it, but we can't even start to look to improve this until we understand what it's based on. Now, previously, if a minister isn't getting up to answer questions, we can rely on the regulatory impact statement to give us an idea. But it's quite clear, when this is read, that the government didn't give departments enough time to actually come up with analysis to assist Parliament. And that's not the department's fault. It's another example of the government cutting corners to try to avoid scrutiny, which makes it even more important that the minister stands up and answers questions. But if we dive into the regulatory impact statement enough, we will see that the government's claims that this bill will help the housing crisis appear to be unfounded. I say appear because it hasn't been able to reach that conclusion because they weren't given enough time. And the only way that we can get to that conclusion, or otherwise, is if the minister answers questions. So I'll bring it right back to the most basic point. In the absence of a response, once the minister does respond, we will certainly have more questions, but I'll keep it real simple. How does this bill help solve the housing crisis? There's no mention in this bill about building houses. And actually, we've got to look at this bill and this part in the context of the other changes that this government has made. Because the minister needs to answer that pretty simple question in the context of them reversing the changes the previous government made around interest deductibility, in the context that, at least in part, but I would argue predominantly because of that change, rents have gone up 7%, according to the regulatory impact statement, in the year leading up to this. What is going on here? We need to know from the minister how this is going to solve the housing crisis.
Mr Chair.
The Honourable Tama Potaka.
Thank you for the opportunity to stand and respond to some of the questions today. I was really unfortunate I was unable to sit in the chair in relation to the pet bonds because that's quite an issue dear to my heart here in the fishbowl of Wellington. The changes that have been proposed in this part of the Act, sensible, much needed, and remove some of the barriers to ensure supply and flexibility for landlords in the market. Of course, there's been some observations, may I say allegations, around rent increasing as a result of some of these changes. But as we know, rents have dramatically increased over the last 5 or 6 years, and over the last 12 months there's been some stabilising of rent. But rents do get influenced by a number of matters. For example, immigration, supply, wage growth, and it's clear to us that an increase of an average of $170 over the 6 years prior to the 2023 election, despite an extraordinary amount of coin being tipped into the housing market by way of subsidies and build costs, despite that, rents continue to increase. Despite some of the current arrangements around terminations being put in place, rents continue to increase at a pace that has actually contributed significantly to the cost of living catastrophe that has faced ordinary New Zealanders, including those ones in West Auckland. The view that changes is that changes will increase supply, and whilst that might come as a surprise to our colleagues on the other side of the whare, It is our view that the changes that are being proposed, in the context that are being proposed, and together, will increase supply at the margins by giving landlords great flexibility to rent to tenants and to a broader suite of tenants. And that's something that I've obviously witnessed, being involved in the property sector myself for the last 2 decades. And the sense that, and the view that our team has on this side of the house is that by making these changes, we're able to see a lot more landlords be interested in broadening the suite of tenants and people who may rent homes, rented tenancies from those landlords, because there's an increasing flexibility to deal with some complexities which currently cannot be dealt with under the current legislation. You actually get more choice for access by tenants. And whilst there have been some observations around 52.8% of property associations and landlords opposing the change, actually within some of those associations and groups who presented or who submitted during the Select Committee process, there are a number who submitted on behalf of many, many other landlords. So yes, acknowledge the submitters and the percentage of submitters, but when you actually get to the percentage of landlords opposing or not opposing, we don't and we haven't been able to penetrate that number. And whilst there are some observations around the reletting and the impact on the tightness of the market, recent evidence suggests that actually the time taken to relet properties is actually longer, suggesting that the changes and the approaches that we have made actually showing that the tightness in the market is easing. So again, we believe that there is a sensible, much needed change, and that's captured here in this part of the Act. We do believe that it will increase flexibility for landlords, but also generate a greater opportunity for tenants to access rental arrangements. Very sensible, and I commend Minister Bishop for his hard work on this matter.
More commentary.
Yeah. Okay, there was a lot of flexibility being done by Tama there in terms of logic. Okay, this is not a pro-tenant bill. Yes, okay. There is one aspect of the bill that does help out tenants, which is the pet bonds, but whether or not one can own a pet or not is an issue with renters. But the rest of it is so stacked in favour of landlords, especially when you look at it in combination with interest deductibility, which based on rental properties, which allows landlords to deduct their mortgage interest costs from their rental income, which reduces the amount of taxable income and in turn tax owed. So yeah, it's like, let's not kid ourselves here. This is a pro-landlord bill.
And also, like, the other thing is, how many of these landlords are reporting to the IRD they're doing things like maintenance, but not doing maintenance?
Good question.
That's the other thing that goes in there is because, like, in a normal tax return, like when I file my IR for an IR 10 for the business, I don't get asked to provide a ton of receipts to back up that case or bank statements or anything. It is taken at the goodness of my word. Now, that's for my business. Mm-hmm. And I mean, this was in days when I was filing the tax returns, not when now I've got an accountant again, the accountant files that, which reduces the need of doing that. But how many, landlords are saying they're doing the right thing on paper, but not doing the right thing at all, and probably don't have the invoices or the receipts to back up they're doing the right thing?
But from reading the bill, there's nowhere in the bill which says that you have to provide evidence of what you use, what you're doing.
Even if you say deduct a bond, the only time you have to provide evidence is usually if it goes to tribunal when there's a dispute.
Yep.
So yeah, you could sit there, and I mean, that was proven that there was one particular person who used the same receipt on a bond deduction across multiple tenancies, and it was only got called out when the same adjudicator who adjudicated over a previous case go, that's the same receipt, I've seen that before. Because I mean, serial litigants, they are known at the tribunal.
100%. Yeah, it's just another Tuesday to them. They literally consider it to be like part of the cost of doing business. I think that the thing to acknowledge is like, okay, what is the actual material reality of this bill? What is the intent? And ultimately, like, what National is looking to do and how they're planning to justify this bill is the argument that it's going to give some people the confidence to enter the private rental market as suppliers that otherwise wouldn't. Here's the thing that I haven't seen anybody acknowledge, though. There are some people that you don't want as suppliers in the private rental market, period. Yeah. Because they're look, I mean, I don't know what the rules are around language, but they're fucking horrible. They're horrible people, and they're horrible service providers. And it's not even a service, right? Like extracting an economic rent is not the provision of a service; it's theft. But that's a discussion for another time, right?
Yeah, but I mean, it's like you can be rude to your tenants and get away with that. But if you go, excuse me, bitch, but don't sit there and tell me, you're going to be having cow's milk whether you like it or not, and what is the customer going to do? Walk away and probably never come back to my business.
That's right. Yeah.
You can
but if it's someone's home, 100%. And the other thing too, right, is like even if we're talking about rental prices, like something that Tama himself acknowledged during his speech is that rental prices are not primarily dictated by costs. Right? No. They're primarily dictated by what the market can afford to bear, which is really just a sanitized way of saying, like, what's the most that we can extract from tenants? That's the reality of it. So, like, this whole interest deductibility thing was a nice tax holiday for landlords and has had, like, very little to no material impact on the actual costs of rentals themselves. The one thing that ironically enough, arguably might if it drums up a little bit more supply in the market. But here's the thing. You also have to consider the quality of the supply, right? Somebody who was unwilling to enter the private rental market as a supplier, as a landlord previously, because they didn't want to deal with the reality of tenants having the ability to dispute an eviction. Like, these are not people that you actually want as providers in a community for rentals. Like, that's unhinged. Like, and I think that's the thing that I'm just so shocked hasn't been part of this discussion, right? Is because, like, the reality is, and here's the other real reason why National is doing this, right? It's because they want people with insecure tenancies and who otherwise would not be eligible for the private rental market out of social housing and into the private rental market. Because in order to access social housing in New Zealand, the primary question is not whether or not you can afford the private rental market the way that it used to be, right? And instead, what it now is a question of whether or not you have access to the private rental market. Cost is a very lowly consideration, even though it should be the highest, right? But it's typically people that have like some kind of custody or family court issues, or like criminal behavior past, antisocial, et cetera, right? That for those reasons are excluded from the private rental market. Here's the thing, though. If you put those people in the private rental market into extremely insecure tenancies, like, this isn't going to promote a lot of pro-social outcomes for anybody, right? Like, okay, it's like you're out of social housing now, but now you're going into, like, these terrible tenancies or these homes are likely also going to fall below standards. Because the other thing, too, that I wish I could remember the name of the paper, the article off the top of my head, but like I remember reading recently that there was like a correlation between the insecurity of a tenancy and the quality of the housing stock. And would you be surprised to find out the more insecure your tenancy is, the worse the quality of the housing stock is? And then if we think to the impact that has on our health system and on our people, it's just, the whole thing is bad. It shouldn't exist.
Yeah, slumlords. This is basically National's way of trying to line their own pockets.
It's not a pro-landlord bill. It's a pro-slumlord bill. You're 100% right.
Yeah.
Now, here's one thing I want to ask is, are letting fees back on the cards? Or is that something that has been killed for good?
Sorry, could you provide a little more context about familiar?
So what used to happen was, if you were a property manager, you could charge a 1 week letting fee. In addition, it had to be part of it. It was a maximum total of 6 weeks, but you used to charge a letting fee, which is usually 1 week's rent plus GST for securing the rental, which was removed back in 2019 to deal with the 2019 or 2018, because the fee should have belonged with the landlord who owned the property, not with the tenant who's moving in.
I didn't see that in the bill. I do know that currently landlords or their agents can't charge letting fees.
So that possibly means that letting fees have gone. They have not reintroduced letting fees.
Sorry, I'm confused. I don't recall that being a part of the discussion.
I don't think that was part of the bill. But that was an old law, and you know how this is bringing back some of the status quos of the old laws.
Oh, are you like making the rhetorical point that we're bringing back like horrible vestiges of the law that
I'll forget about letting fees.
Right. Okay. Yeah. Maybe don't draw attention to that issue, Sam. Don't give him any ideas.
Yeah. Well, it's past third reading. They can't put it as an SOP.
Yeah.
Good.
Okay.